Welcome back to The Full View. Now, Media Monitoring Africa has expressed its concerns, and I'll bring you that story a little bit later on in the program. But to this now, legal analyst Mumelelo Zikalala joins me on this. Earlier this week, we saw the release or the leak of an affidavit deposed by Tshifhiwa Matodzi, the former VBS board chairperson, in which he details over across 70 pages various other actions and persons of interest that were participating in the looting spree and corruption that had taken place at VBS. Now, Matodzi deposed this after a settlement had been reached between himself and the National Prosecuting Authority under Section 1051A of the Criminal Procedure Act, which is colloquially referred to as a plea bargain agreement. How does it work? What limitations does it have? And to what extent can it and does it offer free justice and the pursuit of justice by the NPA in uncovering other forms of criminality that had taken place? Joining me for this is Mumelelo Zikalala, legal analyst. Mumelelo, good afternoon. Thank you so much for your time. Really appreciate it. Explain to us in as crystal a way as you possibly can what a Section 1051A engagement entails.
Good evening to your viewers. Basically, it says, come to us, you've been accused, you are one of the individuals that you would have liked to prosecute. However, if you come to us and tell all and help us or assist us in implicating and making sure there's successful prosecution of other individuals, we are going to have a say in terms of the punishment that you are going to get. So we're not going to find you not guilty or say you are going to let you scot-free. However, the level of punishment and the weight that you're going to receive now is going to be much, much lesser than compared to what you're going to receive at a later stage had you not participated. But there is a condition which is attached. Firstly, tell all. Secondly, make sure that you're able to implicate those individuals as much as possible. And lastly, you still have the court that you still have to convince that what you are saying is indeed the truth, what you are saying is indeed something that took place, and it's going to assist the court in arriving at a conclusion of determining who are the individuals that should be prosecuted and the punishment that is going to be given to them.
Yeah. What happens if the evidence that you bring forward in testimony turns out to not be able to form a prosecutable case, or that some of it is just unprovable?
Well, you run the risk of your plea bargain being set aside. So whatever engagement or agreement that you came up to, you are then going to be told, well, you may have come to us earlier, but we're not going to consider and accept your plea bargain. So the plea then falls away, and we are going to prosecute you in a normal manner. So the same evidence that would have came against the other individuals is then going to come in against you, and you may be found guilty and given the maximum punishment that would have been given to a person that is punished or that is accused of doing what you've been doing. But there's a very strategic thing that must be done by the NPA before all of this takes place. You must make sure that the person is not let go. You must make sure that the person remains someone that can be prosecutable at a later stage. You must make sure that you put in loophole, very strong, tight positions within the plea bargain that are going to make it very impossible for a person to be scot-free. Because if there are loopholes that are there, the person may even go out based on a technicality. So it's important to think it through before you consider it.
Yeah, and is it mandatory, as per what is typically the case in court proceedings, that the settlement agreement become part of court documents and therefore become publicly available? Because at the moment, we're not quite sure what was on offer by the NPA to Tshifhiwa Matodzi that brought about this plea bargain agreement.
That is usually something which is going to be stated within court. So when they appear back in court, the court will be told, we have entered into a plea and settlement and as a sentencing agreement, this is how it's going to be. This is what the person has told us. Let us tell you as the presiding officer or as the judge that this is what the person has stated, and this is the type of sentence in which we are looking as part of punishment. Is it acceptable to the court? Because the decision must still be taken by the judge whether they accept it or not. This is to eliminate whether soft settlements which are going to take place between accused and the prosecution. So you need that independent third person who's going to come in and say, I'm not accepting this, or I'm accepting this because I can see that it's going to assist at a later stage. But usually you would only accept this type of evidence and only accept whatever sentence agreement which is going to come back after the evidence has been produced, after the evidence has been tested, to run away from the risk of accepting and letting someone go. And when you've done that, either they do not want to participate anymore, or even when they participate, they're not doing so comprehensively or bona fide. So they'll be stating things. However, it wouldn't be things that are really what ought to have been stated in the proceedings, or things which are going to successfully prosecute and make sure that the individuals that are in the accused box are convicted.
Yeah. In the calculation of a plea bargain offer, typically the state or the prosecutor would have to ask themselves, can this person help us be led to the mastermind behind the crime? But in this instance, the calculus is the other way around, because the mastermind is Tshifhiwa Matodzi, and he had admitted to such. He was the instigator, coordinator, as well as the convener of the crime and corruption that took place at the VBS Mutual Bank. He's not leading us to somebody more powerful, more significant, or certainly more corrupted than he is in that instance. To what extent is that in the interest of justice?
I think in this case, they look at it in terms of numbers to say how many other individuals or accused can you be able to gather, not necessarily maybe on the status of the individuals that are involved or to their level of being active. Now, it does have a certain advantage if you're going to have the mastermind, the master player, the person who drew up all the plans, executed all the payments and the transactions, will be able to testify in court to say, I gave so and so a million rands, I gave another individual 300,000 rand, we met on this date, and this is what has taken place. But you need to be very meticulous as the NPA when you're prosecuting the other individuals in terms of saying, what other collaborative evidence can I find other than the one that has been produced by the individual that has drafted the affidavit? The more collaborative evidence I have, the much better, because that means I'll be able to get the type of prosecution and the type of sentence in which I'm requiring from these individuals, which is why I think maybe in this case it was really a leak. That particular affidavit shouldn't have made it into the public. What they've done is that they've alerted many other individuals to say these are investigations that are taking place.
Yeah, can I pause you then? I mean, many of them were at pains to respond to that, like former Director General of National Treasury, Dondo Mokgojane. But it was a leak, and the NPA bemoans the fact that it was leaked. In fact, they are saying they're considering their legal options, such as potentially interdicting any further publishing and reportage by the media about the substance of that affidavit. It's a little too late on the fact. It's effectively a moot exercise. But what legal remedy does the NPA have in further reportage and broadcasting around this document and any other related matters in this case?
I think on this one, they would say we're now classifying it as certainly evidence that is still being investigated. So if you report on it, you would be jeopardizing the administrative justice and obstructing the administrative justice. So when it comes to common law principles, you can be prosecuted on that. Also, during the NPA Act, any disclosure of information, if you're not the individual that is supposed to disclose that particular information, you can be prosecuted for that. That is famous from the recent case against Asquith Billy Down and Ms. Karen Moore that has taken place. So the same provisions would then apply to an individual that has published that particular material information after being told that we're still investigating. You are jeopardizing the manner in which we're doing our investigation, and if you do so, then we're going to come back and punish you.
Can I take you back to the 2007-2008 case, which is the independent newspapers versus state security? At the time, independent newspapers published sensitive classified documents pertaining to state security. The minister then took them to court and said, well, you're jeopardizing state security. The court held in favor of independent newspapers to a very large extent in that case, saying that it is in the public interest to know this, right? Here are many actors in this VBS saga who are state actors who corrupted the state and looted from the people, or at least subverted the laws. Surely it is in the public interest in that instance. How does the court adjudicate the balance and calculus between what is in the public interest or what is in the interest of the investigation?
I think in this case, the court would then say, this is still part of an ongoing investigation. So if you alert individuals that you are coming for you, you are then jeopardizing the very same investigation in which we seek to protect. So the other one, maybe you could understand in terms of saying the information is with them, it's going to remain there. If you want to get hold of it, there are ways and channels in which you can apply to. But in this case, once the information has been leaked out, once the information is still in possession of the NPA, it is still being utilized for a much greater purpose than the one which maybe within the state security would have been considered. So in this one, it is much more crucial that the information is held in abeyance for a bit. It is going to come out at a later stage when prosecutions are about to take place. And if information is leaked and it lands in the wrong hands, you are jeopardizing the very same investigation, and you're going to lead to individuals that ought to have been prosecuted and maybe convicted being let scot-free just because information was disseminated at the wrong time.
Yeah, Mumelelo, Zikalala, thank you so much for your time and your insights. Always a fantastic interlocutor in helping us understand these dense and complex legal matters. Appreciate it.